Good morning. I'm just going to wait a few moments while everyone gets connected to the Zoom call here. All right, it looks like we have everyone connected as far as I can see and in the room. So I'm going to go ahead and get started with my portion of the introductions here. It is February 2nd, 2023. Good morning, everyone. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This is a status conference in the matter of the pending proceeding on the alleged waste, unreasonable use, and unreasonable method of diversion of water by Douglas and Heidi Cole and Marble Mountain Ranch from Stanshaw Creek in Siskiyou County. This status conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time during this call you are experiencing technical difficulties trying to communicate with us, please send us an email to the AHO at admin@hrgoffice@waterboards.ca.gov. AHO staff are monitoring that inbox and they can alert me that there are some technical problems going on in the background. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Amy Blanc, and Kyle Woldridge. I'd like to move to appearances at this time. To do that, I'm going to identify each of the entities from whom the AHO received NOIs to appear at the status conference. And as I do, if you are representing that entity today, please unmute your microphone and state your name. And as we proceed, however, if you would please keep your microphone muted except when you're speaking, that helps us minimize background noise and other distractions. So with that, I will turn first to Marble Mountain Ranch.
Okay.
Would you please introduce yourself?
Douglas Taylor Cole.
Thank you, Mr. Cole. And is Ms. Brenner joining us as well today?
She should be, yes. I see her on file there.
I see her and I see her unmuted and with video. I think video's on. Ms. Brenner, would you like to introduce yourself? I don't think we can hear you. I'm not sure why. You're not muted.
How about now?
I can hear you now. Thank you.
Thank you. Good morning. Barbara Brenner on behalf of Marble Mountain Ranch.
Thank you. Good morning, Ms. Brenner, and good morning, Mr. Cole.
Mm-hmm.
With that, I'll move to the prosecution team for the State Water Board.
Hi, this is Kenneth Petrozelli here for the prosecution team for the Division of Water Rights. I have Carson Capps assisting me today, who will also enter an appearance.
And my name is Carson Capps, and I'm here to assist the prosecution team in Kin.
Great. Thank you, Mr. Petrozelli and Mr. Capps. California Sport Fishing Protection Alliance.
Chris Schutz for the California Sport Fishing Protection Alliance. Good morning.
Thank you. Good to see you again, Mr. Schutz. National Marine Fisheries Service.
Good morning, this is Justin Lee. And with me, I also have Sherry Whitmore, Chris Kiefer, and Margaret Towser.
Thank you, Mr. Lee, and thank you to your colleagues as well. Good morning. Thanks for joining us. Pacific Coast Federation of Fishermen's Associations and Institute for Fisheries Resources.
Good morning, Glenn Spain with 1N, S-P-A-I-N is last name. I'm here as General Legal Counsel for those two organizations.
Thank you. Good morning, Mr. Spain.
Good morning.
California Department of Fish and Wildlife.
Good morning, Kurt Babcock, Program Manager, Northern Region.
Good morning. Thank you, Mr. Babcock. Old Man River Trust and Conrad Fisher.
Hi, Conrad Fisher right here.
Thank you. Good morning, Mr. Fisher.
Good morning.
Water Climate Trust.
Good morning, Paul Kybell of Water and Power Law Group on behalf of Water Climate Trust.
Thank you. Good morning, Mr. Kybell. And finally, I have the Karuk tribe.
Good morning. This is Taz Soto, and I have Craig Tucker and Dravette Hunt with me.
Thank you. Good morning, Mr. Soto and colleagues. Is there anyone else on the call who plans to participate in the status conference who has not already had the chance to introduce themselves this morning? Good, thank you. All right, we'll get started. I did want to say that the AHO received status conference statements from the following entities, which are now posted on the AHO FTP site for this matter. We received statements from Marble Mountain Ranch, the prosecution team for the Division of Water Rights, California Sport Fishing Protection Alliance, Conrad Fisher and Old Man River Trust, and Water Climate Trust. I'll pause there. Did I miss any status conference statement that any other party may have filed? I did read all of those statements, and thank you very much. I really appreciate the information. As you might have anticipated, the purpose of my questions for the status conference was to understand the updates about where we are today, given the period of time that's passed since the hearing in this matter was held. I thought it made sense to at least check in and see if any significant progress or other changes had occurred. I am going to ask, like I said, I read the statements and I read them carefully, but I will ask from each of you for a brief summary of your statement. I think that would be helpful to all the parties. And it also will give you a chance to give a brief summary and then respond to each of you if you would like to respond to any of the other status conference statements that were filed. My overall purpose for the status conference today is, like I said, to get these updates and just figure out where we are and how to get this matter moving forward to some kind of resolution. I understand from the status conference statements that none of the parties are seeking supplemental hearing days and don't think that that would be necessary. And really everyone seems to be asking the AHO to move forward based on the evidentiary record we have, as I understand it. Although, like I said, I'll turn to all of you to correct me if I'm wrong in my understanding here. I also understand, based on Marble Mountain Ranch's filing, that some of the operations on the ranch may have changed since the hearing in this matter, and there are some plans for additional changes. So which raises questions to me about whether that may affect any order that would come out of this proceeding and what the corrective actions that the prosecution team may be asking for. I also understand the statements by the fisheries groups about the importance in obtaining a precedential order in this proceeding because of the larger policy implications and questions about wasteful or unreasonable use of water. So I also appreciate that point here. I'll just tell you up front, so you will all have a chance to respond. My initial thought coming into the status conference is that it may be appropriate to direct the prosecution team to consider the corrective action section of the draft order, which I believe is dated August 30th, 2016, and lists corrective actions in a table, and to take a look at those, to talk with, meet and confer with Marble Mountain Ranch on those. And I think it would be appropriate to possibly meet and confer with the regional board, since there doesn't seem to be an update on what is going on with that cleanup and abatement order that's associated with some of these diversions. And then submit a revised version of that table of corrective actions to the AHO with updated timelines. Obviously, the dates on that table are no longer applicable. And that would assist the AHO in its further consideration of how to issue some kind of order for the board's, well, a proposed order for the board's consideration. I would certainly give all of the parties an opportunity to comment on whatever the prosecution team submits to us. So there would be, you know, it wouldn't be a one shot. It would be, you would have a chance to respond to one another in that. But that was my initial brainstorm about how to move this forward in a way that's constructive and will get us to some kind of resolution on the matter. But I want to turn to each of you. I think I'll look to the prosecution team first, and then I'll turn to Marble Mountain Ranch, and we'll go down the list so each of you have a chance to make any comments if you would like, but if you could please, if you filed a status conference statement, summarize your position, and then provide any responses to the other status conference statements, and then the information I just threw at you out of the blue. I would appreciate that. So I'll turn first to you, Mr. Petrozelli.
Thank you, Ms. Kenzie. We, the prosecution team, believe that the existing record is adequate for the AHO and board to issue an order. We are greatly concerned about the significant delay that has already occurred in resolving this matter and the additional delay that would likely occur if we were to reopen the record for additional testimony, field visits, evidence briefing, etc. So we think that can best be addressed through changing conditions, ongoing changes. We believe these can best be addressed through a sufficiently flexible order, perhaps with some adaptive management built into it. And I think that's where we are.
Do you have any additional comments on the opportunity for the prosecution team to submit a slightly revised version of basically the ordering section of the draft order from 2016?
Well, we certainly believe that I think it's certainly fair that the timelines may need updating since it's been 5 years. But it's also important to focus on the goals that the order is trying to achieve, and less so getting caught up in the very fine details of how those goals may be achieved, because we want to give the ranch, we want to give the respondents sufficient flexibility in how they achieve those goals. And it's hard for us to know what those goals would be without seeing the order from the board that determines the issues that were before it.
So is it your position that if the board were to adopt an order that included the ordering section and corrective actions as it is drafted in the 2016 draft with obvious updates to the timeline, that those terms would be sufficiently adaptive to account for whatever it is that the Marble Mountain Ranch has already done and the steps were not done?
Yeah.
Right.
We think so. We think so. And it may just mean they're farther along on the path to compliance than they were 5 years ago.
All right. Thank you. Anything else you'd like to comment on right now, Mr. Petrozelli?
Not at this time.
Thank you. Appreciate that. With that, I'll turn to Marble Mountain Ranch, either Mr. Cole or Ms. Brenner, if you would like to chime in at this point.
Good morning. This is Barbara Brenner. I'll chime in and Mr. Cole can follow up with any additional details. As we indicated in our status conference statement, there's been significant operational changes to ensure that there's no discharge into waters of the U.S. or the state. And so that the system has been stabilized significantly. There's no evidence, as suggested by others, that there's any kind of discharge into the waters. The additional efforts to minimize the hydro use of the water right, so that we've got the solar system just about completed and a new micro hydro system that will use significantly less water to produce energy is getting put into place. And the photographs that were submitted earlier this week kind of evidence what's actually happening out there today compared to 5+ years ago with the system. There is no, we're not discharging after the water is used. Instead, it's going into storage. And any water that could be, any increase in water use would do the same. And there isn't a need and a desire to consider additional storage tank and to allow, once the micro hydro system's put into place, more use of that versus, burning fuel through the generator system, which has its own environmental impacts. We've not seen any issues downstream of the diversion point, and feel like we've fully complied with what the prosecution team has been concerned with. And frankly, would like an opportunity to engage, offer a settlement to the prosecution team and put this to rest through that type of meet and confer and settlement negotiation. And with that, I'll leave it to Mr. Cole if he has anything additional other than what's been stated in our statements.
Thank you, Ms. Brenner. Mr. Cole, please go ahead.
Yeah, I'd like to just summarize the evolutions in our diversion that have happened. Historically, this is a 150-year-old gold mining diversion from Samuel Stanshaw, and it's evolved over the decades to support homestead ranching and other activities historically, and was codified with a presidential proclamation signed by President Taft in 1911. And we've continued to operate that, but the diversion that we inherited historically as a 150-year-old gold mining diversion was not environmentally designed. It was to produce gold. So we had, as we moved to the ranch 3 decades ago, no capacity to store any water, or did we have any domestic water which met compliance requirements from the Water Quality Control Board for domestic consumption, nor did we have any way to store or utilize electrical production from it other than direct consumption. So it was very complicated and impossible to shut the ditch off when we first came here. So the ditch had to be continuously running in order for us to drink, in order for us to irrigate, in order for us to have electrical power. And that led to many issues that are now resolved with our improvements, fundamentally based on creating, first off, storage capacity. So we put initially 2 2,600-gallon water storage tanks in place in a modular system, and now we have developed it to about a dozen of these same size water tanks. And what this allows us to do is to shut the ditch off and have a supply of water so that we can maintain the ditch and improve the ditch. We've also, prior to the hearing, shut off our hydro plant so that we could put that problem out of the issue, and have been living entirely off of diesel-driven generators. And so, the carbon footprint of that has its issues as well, but it's not directly related to the water board issues. It's just a larger environmental issue. But as we've developed the capacity to turn the ditch off, to maintain it and still have consumptive water, that's allowed us to improve the stability of the 150-year-old gold mining ditch to where now we have a berm that's wide enough that we can drive from diversion to the base of the berm in a matter of like 2 to 3 minutes on an ATV, so that we can access it quickly for readings of our diversion quantity, and to regulate, do quick and appropriate regulations prior to a storm pulse or any other need, so that we can manage the flows effectively. Previously, we had to walk the entire ditch by foot. That would take about 45 minutes, and it was problematic because it made it very difficult to be on the site when we needed to maintain things. We have, in the last year, refinanced our our ranch mortgages and finances to enable the construction of a solar facility that will be site-wide in size. So this will be probably, I'm not sure entirely, but it may well be the largest solar array in Siskiyou County, if not at least in the river corridor. And the only issue we have to operating entirely off of solar for power generation is that in winter months, we have periods of time where we have long rain and snow points where we can't generate enough electricity via solar. So we're migrating from small hydro to micro hydro to back up the storage capacity of our battery bank that is now in place for the solar plant. We expect the solar plant will be completed within about 2 weeks. We can reduce the quantity required to generate electricity once we go back to hydro. And again, reiterating that we have not used hydro since about a year and a half before the hearing in 2017. And after the hearing, we've just lived off of our diesel generators for power consumption. Now, prior to the 2017 hearing, we shut off the hydro plant and we stopped letting water exit the terminus of our ditch line and enter back into Irving Creek. So we've, as far as the issue of waters going back into Irving Creek, it hasn't been an issue because we haven't used it. So storage of water has allowed maintenance and improvements. Storage of power in a battery bank will allow us to further reduce need for hydropower generation, but it won't entirely eliminate it. During the periods of high water flows in Stanshaw are the periods of time when we would need to divert water to supplement the loss of solar generating capacity. So the seasonal evolutions are quite appropriate. In the summer, we have a plant that is engineered in size and capacity that we expect that we would not have to divert any power generation water at all through the course of the summer, the periods of time when the Stanshaw Creek river or creek is most sensitive. So the seasonal evolutions of our need for power generation via hydropower match nicely to the availability of water and the needs of Stanshaw Creek. So that's the fundamental difference, is our capacity now to shut off the ditch due to storage of water and power for periods of time for maintenance and improvements. We are not required to continuously divert water just so that we can have something to drink out of the faucets. I feel like this is a signature sort of a diversion and water use facility that might be noteworthy for future people to look at, in that it combines hydro, micro hydro, solar, and backup diesel for people that are not capable of being connected to the grid. I can't imagine anything that would be more environmentally sound and yet still provide the services that are needed for our facility. Basically, that's the summary I have for you. I can't imagine anything more that we could ever do.
Thank you, Mr. Cole. I very much appreciate that summary and overview.
All right.
Thank you. I'd like at this time, I'm going to move down the list. If you're not required to have comments, but I will just step right through the list. So I'll turn to Mr. Schutz. Do you have any other comments that you would like to add?
No, in summarizing the pre-conference statement that CSPA submitted, we agree that the record is sufficient to make a decision. We would not like to see delay. We're very concerned with delay. Any additional information gathering or site visit or anything like that should be limited, in our view, to whatever is needed for the AHO to make a recommendation to the water board. If there are things in the record that are unclear or insufficiently developed for the hearings office to render a decision, then some kind of information submittal or briefing copied to everyone else would be the appropriate remedy. And we'd like to see this moved along. I think CSPA got involved about 20 years ago, and this has been going for a long time. Thank you.
Thank you, Mr. Schutz. I will turn next to NIMS, Mr. Lee. Do you have any comments?
Good morning, thank you.
Thank you.
We would like to make a comment about item 12, but we will defer to that topic later.
I wasn't planning, is it item 12 in the status conference statements? Let me pull it. What is item 12? You're talking about item 12 in my list of questions. Is that correct?
That's correct.
Shuffling through to see what this is. So you have other issues that we think we should consider during the status conference. That's item 12?
That's correct.
Okay, let's, I will make a note and we will come back to you once we get through this and you can make that addition.
Thank you.
Thank you. I will turn next to Mr. Spain. Do you have any additional comments?
Thank you. Yes, one, of course, we agree with the CSPA statement, and I think that the record is more than adequate to move forward. The biggest single problem here is delay. This does no service to anybody. Certainly the landowners need more certainty in what's required of them. Certainly the fish need more certainty that there will be remedies. And as soon as possible. I was noting that 25 years have gone on in this process, and it is time for some closure. Updating the CAO, I think, is the best option, and that's the place to begin.
Thank you, Mr. Spain. I don't mean to cut you off. Did you have anything else you'd like to say?
No, I'll reserve time if necessary.
Thank you. I will turn now to Mr. Babcock and the California Department of Fish and Wildlife.
Yeah, good morning. Basically, in short, I think there's sufficient information in the record that our department has provided on flow recommendations, supporting NOAA's flow recommendation in the past to proceed and conclude this process. I agree, delay has been a big issue. I do support the changes that the Coles have made on site to be more efficient with water. That's, I think, just clear evidence that efficient use of water is feasible, and also evidence that previous use was unreasonable. In the recent water rights statements of use, I cannot say whether or not the reduction is enough to meet the flow recommendations for in-stream flow bypasses that we and NIMS previously supported. I have not been able to do that as yet, but it certainly is a substantial reduction in use and much better. Also, as far as finalizing this process, we had mutually agreed to basically put on hold resolving our permit, our lake and stream bed alteration agreement for the substantial diversion of water from Stanshaw Creek. So that will be good to resolve at the end of this once this is finalized. And it should be hopefully able to be consistent with whatever comes out of this process. And I believe that's it. Thank you.
Thank you. Thank you, Mr. Babcock. Mr. Fisher, do you have any comments on what we've discussed so far?
Yes, thank you. I touched on some of this in my statement, but since perhaps some new issues about Physical Solutions have been brought up. I should probably say a little bit more. Again, Conrad Fisher, I've worked my entire adult life for public interest organizations, and a lot of that, just for context, has been around in-stream flow issues, deciding how much water the law says should remain in-stream versus how much should come out. That's my day job, but I am here today as the landowner / water right holder. As a white person, it makes me feel uncomfortable to say that, but I am the landowner of the land through which Stanshaw Creek flows. Mr. Cole is not. The creek goes through my land. I'm also the senior water right holder on Stanshaw Creek. I have an unexercised riparian right, and if there is a pre-14 right, it is attached to my land. I am successor in interest. And I think for everyone here, I know there are some new faces, it would be helpful, possibly while we're all talking, to look at maps, just to know where we're all talking about. In the exhibits list, OMRT 1 and exhibit OMRT 6 both have maps that will help you understand what's going on. Because if you only listen, you might think Marble Mountain Ranch is the only relevant property here. Ms. Brenner said that everything has been stabilized. There have not been discharges. We've not seen any issues. My home is downstream. Hers is not. I have seen issues. Shortly before this 2017 hearing, there was a horrible wildfire. The bank is destabilized. This method of diversion, compared to what everyone else does in the area, myself included, is unreasonable by any sense of the word. A ditch that is as wide as a car on a hillside that's equivalent to a Black Diamond ski run is unreasonable. The amount of equipment it would take to have a system that is not prone to washing out is pretty much what everyone else does, and it's not that expensive. Physical Solutions I discussed in the attachments to my 2017 exhibit. Whereas in many other cases where CDFW and NOAA Fisheries say basically how much water do fish need according to the law, it's based on ESA public trust doctrine. It's often expressed as a percentage of unimpeded flow. In this case, we've arrived at about 90, which is good. I would go beyond that. As the senior water right holder, I think Doug and I can meet both of our consumptive needs with even less of a diversion, probably 1% of the creek. And also for context, this has been going on since before Doug or I owned our respective properties. We both acquired them around 1994. Chief of the Division of Water Rights was engaged with predecessors to Marble Mountain Ranch. They determined about 0.1 was the consumptive use. And if there is a pre-14 right attached to Marble Mountain Ranch, it is also around 0.1. So I realize this hearing is not intended to resolve the underlying water right, but when the Coles are proposing physical solutions that infringe upon my ability to produce power in the future, pursuant to my unexercised riparian right, that is also an issue. So I don't believe we need to go there. I think if we can all just agree, the fish don't need to give up water for non-consumptive uses in the summer, then we're fine. Otherwise, we're going to need to resolve the underlying water rights issue. Sorry if that was too much. I'm happy to hear if that didn't make sense. Any questions?
No, thank you, Mr. Fisher. I appreciate that. And I appreciate your references to the maps in the exhibit list. I'm not going to pull them up now, but I'm noting that I don't have the evidentiary list in front of me, but assuming they were accepted into evidence, those are certainly be helpful references. So thank you for those.
Yes.
I will now turn to Water Climate Trust, please.
Thank you, Ms. Kenzie. This is Paul Kybell again for Water Climate Trust. I had 3 points wanted to pass along, and I'll try to keep them succinct. And most of these relate to the questions posed for the status conference related to the possibility of resolving this via a settlement rather than an order. And that's what our written submission spoke to. The first point I wanted to make was just to provide a little bit of context in terms of history and posture, because some of us have been involved a little bit longer. I know you're coming on board more recently. It's very encouraging to hear from Doug Cole a lot of the steps that have been taken in recent years to make the changes to allow more water in stream. And we take note of that and are very encouraged by it. But the posture of this was that a lot of these same solutions were discussed, 10 years ago. And it wasn't until there was an enforcement proceeding that was brought by the State Water Board that these sort of cooperative actions were taken. So for us, that's relevant in terms of why we think an order is a more appropriate form of resolution than settlement. But I also want to take note of the efforts that have been made by the Coles. And in my mind, those efforts actually demonstrate that there really were feasible alternatives all along between a combination of more efficient, smaller hydro and solar and other combinations to deal with this, which is actually very relevant to the issues that were briefed, which is the tests for reasonable use and tests for public trust often hinge on whether there are feasible alternatives. And what has been done in the last couple of years has demonstrated there are feasible alternatives. So I think that's important. The second point, and we highlighted this, is that a lot of effort over the past maybe, particularly 7 or 8 years have gone into this hearing. And yes, there's been a lot of work and resources and time that have been put in by the tribe, by NGOs, by federal agencies. But I specifically wanted to call out the work of the State Water Board's enforcement unit, Ken Petrozelli and his colleagues. They have spent a lot of time and energy briefing these matters as to why it's violative of reasonable use law, as to why these circumstances are violative of public trust law. And I would like to see that work results in some clarity going forward, so we don't have to have another hearing every time these issues come up again throughout the state of California, that we can get some clarity of, under circumstances like this, what does reasonable use mean? What does the public trust mean? So that all of us, including the State Water Board, cannot just redo this over and over again. And the thing about a settlement is that usually no one admits anything, right? We agree on the remedy, but no one agrees on what it means in terms of precedent or what reasonable use or public trust standards on. And I know for my client, and I can only speak for my client here, yes, there was an interest in trying to resolve things on Stanshaw Creek, absolutely. But there was also an interest in knowing that there are similar thermal refugia and similar diversions happening throughout the Klamath Basin and even throughout California, and being able to get some real guidance was a big part of why all those resources and time and money were put into it. So we would really, my client would like to see this in the form of an order rather than a settlement. And the last point I'll wrap up is, in the event, notwithstanding what I just said, that things go the way of settlement rather than order, from a Water Climate Trust standpoint, we would want certain things to be in that settlement. One is, we don't think it would be appropriate that it would be a settlement just between the State Water Board and the Coles, that the other parties that participated in it should be parties to that settlement so that they have a direct right of enforcement and they don't have to rely on the State Water Board to enforce it. In terms of enforcement, quite apart from being parties, we would want strong enforcement provisions. And, I think 2 in particular come to mind. One is that if there's a material violation of the settlement, that the parties are entitled to seek injunctive relief, to require enforcement, and that we could do that independent. I'm just speaking Water Climate Trust. If we think there's a material violation, we don't need to convince the State Water Board that there is, so they do something. That kind of triangulation doesn't work very well. And the other relates to attorney's fees, is that if you have an enforcement provision that says that you prevail in a claim for material breach, you're entitled to recover your attorney's fees. And that creates a huge incentive for compliance, so you never get there. But with that said, point number 3 is, we really think under the circumstances that, given the resources and time that have been put into this by everyone, including the State Water Board, and the opportunity to avoid having to essentially, it's not litigation, but having to have another hearing on these exact same facts and issues in the future, because we didn't get an order to clarify, seems like it'll result in a further waste of everyone's resources, including the state water boards. So we would prefer that it's in the form of an order. Thank you.
Thank you. Thank you, Mr. Kybell. I will turn finally to Mr. Hunt with the Karuk tribe. Do you have any comments on what we've discussed so far?
I do, or the tribe does, but I'm going to turn it over to Mr. Soto and Mr. Tucker.
Oh, thank you. Yes.
Hey, thank you. So the Karuk tribe has, occupied these areas since the beginning of time, and they intend to till the end of time. And so it's in the Karuk tribe's interest that there be a resolution of this that's permanent. And so we much favor an order from the water board, some sort of settlement. Mr. Cole and his family have done a remarkable job to comply with the draft order. They have completely changed how they generate power for the ranch. And we're pleased with all that progress. We just want to ensure that progress is permanent, and that in the future, if there are new landowners in the future, or if the land passes to descendants of the Coles, that there's an obligation to manage water in the way that is described in the draft order that Mr. Petrozelli and his team put together. So that's our preference. I think Mr. Cole is already demonstrating that the order can be complied with broadly by the work he's done. And I did want to kick it to my colleague Todd Soto. He's the lead fisheries biologist for the Karuk tribe, because I think there were some claims made in Ms. Brenner's letter about change conditions stemming from Klamath Dam removal that we want to disabuse people of. So Todd, are you there?
Yeah, thank you, Craig. I just want to state that Scanshaw Creek is an important cold water refugia for salmon, and that includes ESA listed coho salmon, and it will always be important despite any actions such as dam removal. So I just wanted to state that, and so that's it. Thank you.
Thank you. Thank you, Mr. Tucker and Mr. Soto.
And just to finish up, if for whatever reason the decision was made to pursue settlement, certainly the tribe would want to be a party to whatever settlement that is.
Thank you. Thank you to all of you for that, for taking the time to go through all of this. I think it's very helpful. I'd like to turn back to you, Mr. Petrozelli. I think based on all of this input, I still think it makes sense and would be of some assistance to the AHO if the prosecution team at least meets and confers with Marble Mountain Ranch about the corrective actions in the draft order from 2016, and just have the conversation. I know you indicated to me that you think the terms there are already sufficiently flexible that and adaptive that those terms, even if adopted as they are, would account for the work that has been done and gone in. But I am going to direct you to at least have the conversation and talk about that and see if any additional changes to those corrective actions might be appropriate, in addition to updating the timeline, which would be helpful as well. Go ahead, Mr. Petrozelli.
We can do that. It's encouraging to hear about the system improvements that the respondents have made. And we can certainly have these discussions with the Coles. I don't see why the HO cannot move ahead simultaneously with doing the work to draft an order. And the reason I say that is because of, in the context of Mr. Kybell's comment, that we really only saw these system improvements once the enforcement action and the hearing occurred. So knowing that the order process is still moving ahead, I think would also encourage the Coles to continue making progress. They've made a number of improvements. It's important to know what these improvements can do, exactly how much would they need to reduce their diversions, what would be the diversion demand of the new system. Previously, there were also discussions about improvements to the ditch, such as lining or piping it, other improvements to the point of diversion. Ultimately, the goal was for the Coles to be able to operate their diversion to divert water in a way that would leave sufficient flow in the stream for endangered fish, habitat, and senior rights. And it's important to know that whatever they've done, that it can do that. And the only way ultimately to hold them to that is to have some kind of order. We can do a settlement order, but we engaged with, there were previously efforts to engage with them for 20 years, and it's probably been 25 years now. So.
Thank you, Mr. Petrozelli. And I will note, I saw hands from Mr. Cole and Mr. Fisher, so I will turn to both of you. But I just wanted to continue commenting on this. I think, first of all, there's one area of complete agreement from everyone on this call, which is the State Water Board needs to move towards some kind of resolution of this matter. And I can assure you the AHO, that's what our role is, and that's why we're here and why the matter is our understanding why the matter was assigned to us. So we will keep moving forward. And then I also just wanted to clarify, Mr. Petrozelli, I will put this in writing, but the direction to meet and confer with Marble Mountain Ranch is not, if you choose to discuss overall settlement, that's fine, but really the direction is to meet and confer with respect to relevant information about the corrective action items in that 2016 order. So it's, I want to try to be clear on that point. I also wanted to ask you, Mr. Petrozelli, if your team would meet with the relevant person at the regional board to find out whether there's any information that would be appropriate for the AHO to know about the status of that CAO. Go ahead, Mr. Petrozelli.
Yes. Please include in the conference statement order if you expect any deliverables and as a result of that and what the timeline would be.
Yes, we're going to get to that. I would expect a deliverable, which would be, the deliverable would be any information you think is relevant to the AHO based on your discussions, but most importantly would be an updated version of, if you suggest any changes, I would assume there would at least be updates to the timelines, an updated version of the order section from the draft order, the 2016 draft order. Does that, would that be sufficiently clear? I think it would also, I mean, incidentally would include things like updating the staff contacts and things like that. I mean, there's just an overall review would be helpful, I think.
Yes.
Thank you. And then we should talk about timelines, but first I want to turn to, so I'm going to leave the timeline outstanding for a moment. I will turn first to Mr. Cole and then to Mr. Fisher and then to anyone else who would like to comment on what we've discussed. Mr. Cole.
Yeah, thank you for the opportunity. So the point that's been brought up that we've only acted based on pressures from government agencies, and that's not entirely accurate. Of course, there's a point to that, but evolutions in technology over the decades have played a significant role in our capacity and availability to make these improvements. Solar projects 3 decades ago are not the same solar projects that they are today. Solar projects that were proposed and investigated at the time of the 2017 hearing are different than what they are today. So we have the cutting edge technology that we're able to put in place that is far more efficient and much less expensive. The capacity of a single solar panel module has increased dramatically over the decades. So the point that we are only acting under pressure from government agencies is a bit misleading. The point is also, it needs to be buffered by the point that, yes, we are trying to comply with government agencies and the larger environmental needs, which we agree with. But two things have happened. Technology has changed and evolutions in our capacity to do work has changed. We have gone with modular-based systems. So as I said earlier, I started off with 2 storage tanks. That's all I could afford at the time. As time has allowed, and I've been able to grow my storage capacity to allow more time to take longer periods of time to shut the ditch off entirely, to do larger and better maintenance issues. I mean, those things all have an impact. It's a snowballing effect where we have increased capacity with technological improvements, which drop the price of these developments. And also our modular approach to this has allowed us to build on it as we go through time. There is no way I could have complied with any of these orders immediately in 2017 or prior in the form that we are right now in 2023. So the heart may have been there to comply entirely, but the capacity to comply has not been there historically like it is now. So the point I want to make is that, yes, the role of the government agencies in regulating us has had an impact, but also our capacity to comply has improved with technological improvements and evolutions in our business model over time. So that's basically all I have to say on that point.
Thank you. Thank you, Mr. Cole. And while you're here, I did want to just ask explicitly whether you and Ms. Brenner are able and willing to meet with the prosecution team about the changes and the operations that you've described in your status conference statement and today, and to discuss how that may affect what the prosecution team is seeking and is proposing. I just wanted to get your confirmation that you're willing to meet with Mr. Petrozelli and his team.
Well, I'm willing to do whatever it takes to bring this to a resolution. Everybody's talking about it's been going on too long. I agree. We need to find a resolution. The only side benefit to that lengthy period of time is it has allowed the technological improvements to happen. The rest of the issue I'll leave to my attorney, Barbara Brenner, and let her make that commitment with you.
Thank you. Ms. Brenner.
This is Barbara Brenner. Yes, we're happy to meet with the prosecution team and suggest any changes and bring the proposed order current. And I would emphasize that Mr. Cole is correct. The technological advances in both solar and micro hydro has made a significant difference in his ability to comply and improve the system, as well as just time of cleaning the ditch and making it more stable. It takes time to make these kind of improvements on such a system.
Thank you, Ms. Brenner. I see your hand, Mr. Kybell. I'll turn first to Mr. Fisher and then to you, Mr. Kybell. Mr. Fisher, you have the floor.
Hi. Yeah, I guess I'm just a little bit confused. I guess if there is going to be a meet and confer, I would suggest that it be with both water right holders who are involved here and not just one of them. Because in the end of the day, we need a resolution that satisfies both of us, including my senior unexercised water right. But I would also say, do we really need a meet and confer? We have discussed physical solutions for 25 years. They're in the record. I don't think this will be resolved in a way that complies with the reasonable use doctrine, unless there is a little bit of prescriptive behavior on behalf of the water board instead of only what can be negotiated. I started this 20 years ago, this discussion with Mr. Cole about what could be done with a fraction of the water. There are hydro systems in the area that for 20 years have been using literally the amount of water that comes out of a bathtub to supply more people. It is possible. It has been possible for a long time. Solar has gotten much more efficient. And just for clarity, from 1995 to 2015, the diversion was enough that I had to watch coho dying every summer. Since 2015, it's been reduced to approximately a third of the creek, whereas before it was maybe the majority of the creek. It should be even less. The cold water plume in the Klamath is important, and consumptive needs can be met with, as the water board said to Doug's predecessors and Doug, point one. So that's, I'll shut up there.
Thank you, Mr. Fisher. I certainly wouldn't discourage, additional conversation. I always encourage conversations among the parties to reach understanding and resolution outside of this proceeding, by which I mean, not in which I, as the hearing officer, would not have a direct involvement. So I certainly would encourage that. I think for purposes here of a relatively efficient and quick turnaround, I think the conversation I'm looking for is for the prosecution team to discuss with Mr. Cole what has been done. Certainly, Mr. Fisher, you and Mr. Cole have, I'm sure, as neighbors to some extent, have things to work out and to talk about, and I encourage you to do that. I also will say that there will be an opportunity to respond to whatever it is that the prosecution team submits. So you'll certainly have another opportunity to tell me what your concerns are, if any, about changes to the proposed corrective actions that the prosecution team may have.
I guess what I'm asking is, to the extent you're asking the prosecution team to confer with Doug, that I be on whatever equal footing, whatever that is, I'd be on equal footing for that.
You would like to have, you're asking for a meeting with the prosecution team? Possibly.
I guess whatever you're asking the prosecution team to do with Doug,
yes,
I ask that they put me on equal footing with Doug in this process. That's it. So if they're trying to, negotiate a settlement, that I be part of that.
Thank you, Mr. Fisher. Mr. Kybell, you have the floor.
Thank you. I don't know what the floor means when you're on Zoom.
I don't know either.
Whatever. I just wanted to respond to some of the comments that Doug Cole made about the ways that technological innovations make implementation, more affordable as they develop. And the perspective that I wanted to share kind of relates to what Conrad said, which is that really up until 2015, the position of the Cole seemed to be that this simply can't be done. It's not feasible, it can't be done. And after 2015, before the hearing, we had the actual hearing, but as the enforcement proceedings were ramped up, even in 2015, they were able to make adjustments to how they provided electricity to their rants, such that they were able, by the time of the hearing, to be operating to have reduced the amount of diversions by 2/3. So while yes, since 2017, there may have been some additional technological improvements that allowed further efficiencies, it's important to understand that chronology, and here's why I think it's important. It's the view of Water Climate Trust that by the time of the hearing in 2017, it was clear that there were feasible alternatives to significantly reduce their diversions then. And that's important because it goes to what reasonable use standards mean, and it goes to public trust law standards. What they mean is that we would like a finding that at the time we did the hearing, as demonstrated by the fact that they were able to reduce it by so much, what they had been doing was, you can view it through reasonable use law as unreasonable, or you could, in public trust speak, you could say, whenever feasible, you're supposed to protect it. Well, the fact that they were able to reduce by 2/3 shows that it was feasible. And I think that whole record of events, if you understand the chronology, is that by the time of the hearing, they had already demonstrated the feasibility of what they could do. That is what we would love to get an order on, so that the rest of us in the Klamath Basin and throughout California have some sense of where you have the ability to feasibly reduce by 2/3, continuing to operate at that level is just unreasonable, or that's why it's important. So while I agree with Mr. Cole, yes, as technology improves, the cost comes down and it becomes less expensive to do. I don't think that changes the record in this case, which was that by 2017, they had already demonstrated their ability to significantly reduce their diversions. And I think that's important to keep in mind.
Thank you, Mr. Kybell. And just to clarify for me, I think I'm understanding you, but you're asking the AHO and the board to continue to look at the evidentiary record that has already been developed and produced through the hearing process, in which closed with the close of that hearing, and not to add any additional evidence to that record. Is that correct?
That's correct, because I think that evidence provides the information that the AHO, you need to evaluate the claims of Ken Petrozelli and the enforcement unit that what was happening, the level of diversions that were happening violated reasonable use and public trust law in California. And now we're talking about the remedy, but that finding would provide such important guidance and would, I think, avoid further need for disputes going forward. It would be certainly very welcomed by my client.
Thank you, Mr. Kybell. Mr. Spain, I see your hand up. So I
Yes.
think at this time, I will turn to you, Mr. Spain.
Just one comment. It's clear that an order is necessary for a variety of reasons, but it's not an either or situation. The landowners can continue to work together. They can continue to negotiate. The agencies and other parties can continue to work toward resolution of what that order says. And I think that's a necessity. I want to avoid this either or kind of conflict. It's not a situation where a little bit of consultation on the side, by formally or informally, would be useful. It is a situation where it would be useful, and it can be done, but we need an order. It's clear after 25 years that it's in the best interest of everyone to know exactly what the goalposts are, where they are, and then getting there is the process in front of us, instead of trying to determine where the goalposts are at the beginning.
Thank you, Mr. Spain. I think at this time I have two outstanding items. One is a timeline for deliverables from the prosecution team, and the second is Mr. Lee had raised that there's another procedural issue he would like to discuss. I think I'd like to turn to the other procedural issue before I start setting deadlines, just so I know what we're getting into. Mr. Hunt, I see your hand is raised. Did you want to comment on some of the issues we've already been talking about?
No, but I'll use this time to just let you know that if there's a process, I didn't see one, but if there's a formal process for updating the service list and everything, is that something that the prosecution team will handle? I just want to make sure, because I know some of the materials there are out of date.
The service list is now handled by my office. So if you would please, any updates to the service list, if you would send an email through that AHO email inbox, that would be the best way. And then my staff will help me and work on that and get that service list updated. So thank you. I appreciate that.
Thank you.
So I will turn back to Mr. Lee, if you would. The suspense is killing me. What else do we need to talk about today?
Okay, thank you for the opportunity. So earlier you caught me off guard, so I apologize for that. We are looking forward to an order from the board as expeditiously as possible. You know, the water diversion should be limited to the amount that can be reasonably and beneficially used. So we are hopefully seeing that the solar power option in the summer could be used to preserve the summer low flows to the maximum extent possible. We feel that maximizing the discharge of that plume will allow fish to more effectively detect the tributary and move into the pool for refugia. In regards to item 12 that I mentioned earlier, you know, dam removal really does not obviate the need for the thermal refugia at the mouth of Stanshaw Creek. While it's going to do great things, it in no way diminishes the importance of that particular refuge.
Thank you. Thank you. Was there anything else, Mr. Lee?
No, I think we're good. Thank you.
Thank you. So at this point, I will turn to a timeline for deliverables from the prosecution team. Then I will look again to the room to see if there are any additional comments. But now I see Mr. Kiefer, you have your hand up. Please go ahead if you would like to jump in.
Yes, I had technical difficulties and joined the hearing late, and I apologize to the hearing officer and the other participants. I just wanted to follow on Justin's comments. Oh, for those who don't know me, I am in NOAA's Office of General Counsel and attorney for the National Marine Fisheries Service. I just wanted to follow on to Justin's comment. There's one conclusory sentence in Mr. Cole's hearing statement about the benefits for the fish in the basin of dam removal. It is unsubstantiated and it doesn't rise to the level of requiring a contested evidentiary hearing. So we believe that the record as it exists through the hearing that is already concluded is more than adequate for the board to render a decision, and we are in favor of an order. So I don't want to open the biological can of worms on what my client, Mr. Lee, has said, so I'll leave it at that.
Thank you. Thank you very much. All right, so let's talk, Mr. Petrozelli, let's talk about how much time you need. I can tell you that the AHO is not, we're not sitting on our hands over here in the meantime. So these processes are moving forward simultaneously. I want to give you a reasonable amount of time to meet and confer and then take a look at the corrective action and submit that to the AHO. Do you have a request about what an appropriate deadline would be?
So I like to under promise and over deliver.
Great.
So I want to set, my initial instinct is 60 days, but that also depends on what you ask us, what you ask for as a deliverable in your order. And it also depends on the Coles availability to engage with us.
I think so. Here's what I would propose is that I would get something, an order out in writing that would set a deadline approximately 60 days out, with the understanding that if there are obstacles to actually setting a time to meet and have discussions, or you start having discussions and you realize you need more time because it's productive, that you could ask for more time. I don't think the deliverable, I'll describe it, but I don't think the deliverable is going to be, like I said, a significant undertaking, I don't think, unless you engage in these discussions and find out there's a lot that needs to be changed, and then you'll tell me that you need more time. So if that sounds appropriate, that's what I would intend to do in a written procedural ruling following this. And then for the rest of the parties, what I think I would propose is an additional 30 days for any other party to respond, if you would like, in writing to whatever the prosecution team submits, the updated ordering section of the draft order that the prosecution team submits. So that is my proposal, which I would do in a written order. Mr. Petrozelli, is there any other comments on this that you would like to make, or anything else?
I mean, just give me a moment.
Sure. I can also turn to the room. This doesn't have to be your last chance, so I can turn to the room as well. Does anyone else have any?
I'm hearing that sounds reasonable.
All right.
Yes. I will note that many of our staff who are involved with this are also involved in cannabis, and cannabis season workloads may affect our ability to meet the deadline. So
I understand that. You will do your best, so we can move forward from there.
Yes.
Looking to the room, does anyone have comments about this timeline that I'm proposing, or are there any other procedural matters we should be talking about today, or other matters that we should talk about today before we adjourn? My intent would not be to set a future status conference. I don't, at this point, if it becomes necessary, or if any of the parties think that a status conference would be appropriate and helpful, you can certainly request one in writing, and we can arrange for that. So that's my current thinking. Mr. Schutz, I will turn to you. I see your hand is up.
Thank you. I would just want to make sure in the discussions between the prosecution team and the Coles and Ms. Brenner that details get nailed down. Mr. Cole, speaking understandably in shorthand, said he's not going to divert water in the summer. And it's important to understand what months he's talking about diverting for his micro hydro and what months he's not. And making sure that the numbers, the amounts of diversion and so forth, those details get worked out. And so it may take some time for those discussions to come forward. And if there are differences of opinion, Mr. Petrozelli could record those differences of opinion, report them out, and leave that to for comment and ultimately for decisions by the AHO about how to craft a draft order. But I don't want to be put in a position to have 30 days to comment on something where it's not clear what the enforceable terms are, or where it would be required in order to have clarity to go back for further discussion. Thanks.
Thank you, Mr. Schutz. I can understand to some extent your comments may have been directed to Mr. Petrozelli. In other respects, I would say that of course, it would be an appropriate comment if you were to consider some of the corrective actions in the PT's prosecution team's submittal to be vague and therefore unhelpful or unenforceable. That would, of course, be an appropriate comment. So this is one opportunity to comment. Of course, whatever work product proposed order comes out of this office, there will be we would issue it. It has been our practice to issue it in draft. That's an additional opportunity to comment. Then that proposed order goes to the board where there's a further opportunity to comment before the board. So certainly this isn't a last opportunity to say what you have to say, but I'm appreciate that the desire for specificity here about what it is that I think everyone wants to know what it is that if there is a corrective action, what does it mean in specific terms? Are there any other comments or concerns before we adjourn for the day? Mr. Fisher.
I guess I would just ask that to the extent there are corrective actions, they be based on what the water board has already determined is reasonable for meeting certain purposes. And in exhibit OMRT 6, that is spelled out from previous water board staff who have been involved. So you can go one of two ways. Usually it goes the way of water board staff must negotiate and has to come to an agreement with a diverter. I, as a diverter, am asking that you be more prescriptive, you or the prosecution team. Base this on what is actually needed, based on numbers of people, numbers of irrigated acres, established needs for heads of animals. Those are already established as what's reasonable. So I would ask that we base it on what's actually happening in Marble Mountain Ranch and work backwards. I'll be quiet there.
Thank you, Mr. Fisher. Are there any other comments, procedural issues, concerns that should be addressed today before we adjourn? Well, with that, I really want to thank all of you for your participation. I know there are a lot of us, and this took some time out of your day. I think this was very helpful for I know it was very helpful for the AHO. I appreciate the efforts by you, Mr. Cole, and also the efforts by you, Mr. Petrozelli. And I look forward to this work product. You will be seeing a written procedural ruling from me within a relatively short period of time with the specifics, as I understand it, about what it is I'm directing the prosecution team to do and including these deadlines. And if there are any concerns about the way that procedural ruling is drafted, you think I didn't address something or may have missed something, certainly you can file a note on that and I will take a look at it. So with that, thank you to all of you once again, and we are adjourned for the morning. Have a good rest of your day.
Thank you.
Thank
Thank you.